what does it really mean to be equal under the law? It's a question that gets right to the heart of the entire American experiment. Today, we're going to dive into the legal framework of civil rights, from its roots in the Constitution all the way to the battles still being fought today. Let's get right into it.
So, here's our game plan for this explainer. We're going to start with the original promise of equality. Then, we'll look at how courts actually test that promise. After that, we'll cover the huge laws that turned ideas into reality, see how the circle of rights got bigger, and finally, we'll land on the civil rights debates that are happening as we speak.
All right, let's start at the very beginning. This fundamental idea of civil rights, where does it actually come from in American law? To figure that out, we've got to get to the bottom of this core phrase, equal protection. It sounds pretty straightforward, right? But its meaning has been hammered out over more than 150 years of intense legal and social struggle. Okay, first things first, let's get our terms straight. Civil rights are all about making sure groups of people get equal protection and equal access. Now, this is different from civil liberties, like freedom of speech, which protect individuals from the government. With civil rights, it's actually about the government stepping in to make sure things are fair for everyone. And here it is, the absolute bedrock of it all. This is the Equal Protection Clause from the 14th Amendment. It was passed right after the Civil War to protect newly freed slaves, and it's basically the engine for almost all civil rights law. It's a direct order to the states. You have to treat people equally. But, that just begs the question, how do courts decide what's equal? And this is where it gets really interesting. The Supreme Court has basically created a toolkit, a set of 3 legal tests, to decide if a law that treats different groups of people differently is actually constitutional. Think of it like this. The government has to clear legal hurdles of different heights. If a law is based on race, it faces the highest hurdle, strict scrutiny. The court basically assumes the law is unconstitutional from the get-go. For gender, it's a medium-sized hurdle called intermediate scrutiny. And for things like age or income, it's the lowest hurdle, the reasonable basis test. This whole framework, it is absolutely essential to understanding how these fights play out in court. So we have the promise in the Constitution, and we have the legal tests. But how did that actually create change in the real world? Well, that brings us to the long, hard fight against discrimination. The Civil Rights Act of 1964 was a total game changer. It was born out of the incredible pressure from the Black civil rights movement, and its impact was massive. For the first time, a federal law said that not just the government, but private businesses, restaurants, hotels, major employers couldn't discriminate. All of a sudden, that promise of equal access was being stitched into the fabric of everyday American life. Now, to really get what this act was fighting, you need to know 2 key terms. The first is de jure discrimination. The trick here is to think jure like jury or jurisprudence. This is discrimination that is written right into the law. Think state laws requiring separate schools. And then there's its trickier cousin, de facto discrimination. Think facto as in fact. This isn't in a law book. It's the kind of discrimination that comes from deep-seated social and economic biases. It exists in reality even when there's no law telling it to. And here's how you can really see the 2 side by side. The early civil rights laws, they were all about tearing down the legal walls of de jure discrimination. But just getting rid of a bad law doesn't magically erase the societal biases of de facto discrimination. And that's why later policies like affirmative action were created, to try and tackle those much deeper, more stubborn inequalities. So this powerful legal framework built to fight racial discrimination, it didn't just stop there. It became a blueprint, a model that other groups fighting for equality could pick up and use for their own struggles. And you can see this play out so clearly. In 1972, Title IX took that non-discrimination principle and applied it to gender in education, completely changing the game for women in school and in sports. Then, in 1990, the Americans with Disabilities Act extended those same kinds of protections to ensure people with disabilities had equal access to jobs and public life. And this pattern, of one movement building on the successes of another, it just kept going. The very same legal arguments that helped women's rights move forward, things like challenging stereotypes and demanding equal protection, they became a direct model for the LGBTQ+ community's fight for equality. I mean, just look at this timeline, you can see the momentum building. It starts in 1996 with Romer v. Evans, the first time the Supreme Court really extended protections. Then comes 2003 and Lawrence v. Texas, which struck down discriminatory state laws. And it all leads right up to the landmark 2015 Obergefell decision, which legalized same-sex marriage by using the very same equal protection clause we started with. It all comes full circle. Of course, this whole story isn't just something for the history books. The fight for civil rights is a living, breathing thing, and it continues to evolve, with new challenges that define the debate today. A huge area of debate right now is voting rights, specifically around voter ID laws. On one side, you have the argument that states have a legitimate interest in preventing voter fraud. But on the other side, opponents argue these laws are really designed to make it harder for certain groups, like low-income, minority, and younger voters, to cast their ballot. It really boils down to a classic civil rights question. Where's the line between security and access? Now, the whole backdrop for this debate was totally reshaped back in 2013. In a case called Shelby County v. Holder, the Supreme Court got rid of a key part of the Voting Rights Act. It was a formula that required states with a history of discrimination to get federal approval, or preclearance, before changing their voting laws. The court said the formula was outdated. And the upshot was, those states could now pass new laws, like voter ID laws, without that federal green light. And of course, modern social movements are constantly pushing the conversation forward. The Black Lives Matter movement, which gained momentum after the 2014 shooting of Michael Brown, really brought public focus onto racial inequality in the justice system. By using public protests and marches, it echoes the strategies of those earlier movements to demand reform and accountability. Which brings us to our final thought. The one thing the story of civil rights makes crystal clear is that the meaning of equal protection isn't set in stone. It has stretched and grown and evolved over generations of debate and struggle. And so the real question for the future is this: as our society keeps changing, how will our understanding of that fundamental promise change right along with it?